You know, when I talk about wrongful convictions, innocent people being convicted of crimes, I do always stress at the beginning, we're not talking about every single case, right? We are talking about those rare cases that go wrong in our justice system. One of the strengths of our country's justice system is that when something goes wrong, we do have processes in place to correct it. And so that's something to be proud of. But it's important that we do have the initiative to go find mistakes and correct them. This movement really got going around 1989 when DNA became a forensic technique that could be used to prove that someone was innocent and had been wrongfully convicted. And so in the early years, which I define as the first 2 decades, 89 to about 2009, the majority of innocence clinics in the country focused on DNA cases. They would take cases where physical evidence was available but never previously tested, and they would test it to show that, whether the right person was in fact incarcerated. Our clinic was founded in 2009, and it kind of represents the second generation of these clinics, where we are attempting to apply the lessons that have been learned from the first 20 years of Innocence Clinic work. As the slide says, as of yesterday, or is that today, the 20th, today, 575 people have been exonerated in cases that involve DNA. That's actually a very small percentage of overall exonerations. Only about 10% of criminal convictions overall involve DNA evidence. And you can imagine why that is. You're not going to get DNA evidence in most armed robberies or carjackings, although it is possible. So these DNA cases, even though they're a small subset, they tend to be cases that people cannot really disagree about. They tend to be cases that are obvious wrongful convictions. And so these have taught us lessons, which is that no system is perfect, and there are flaws in the judicial system that can be corrected if we put our minds toward correcting them. Innocence clinics have tended to only do DNA cases in the past, but ours was created to focus on non-DNA innocence cases. In the 14 years that our clinic has been open, we've had 40 successfully concluded cases. But as was mentioned, I think that might go to 41 as of later today. And all innocence clinics deal with what's known as factual innocence, which is innocence as the average person would understand it, meaning that the person had nothing to do with the crime, was not involved in any way. Of course, there's great work being done by other kinds of attorneys for, other injustices, over sentencing and things of that nature. But that is beyond the scope of the work of the Innocence Clinic. And here we see a couple of our earlier clients as well after they've been released. So just some numbers which, may or may not interest you. Since 2009, we've received about 7,000 applications from people who are incarcerated in the state of Michigan. We only consider Michigan cases. And we've reviewed just about all of them to this point after an initial backlog. And about 10%, 700 of those applications, have been designated for further investigation. The rest, the 90%, were rejected right off the top, either because it was very obvious that the person had in fact committed the crime, or in the sadder cases where the person may not have committed the crime, but unfortunately, there isn't a way back into court. Almost always, it takes some new evidence to reopen a case. And sometimes you may read the transcript of a trial and say, this person seems like they didn't do it. But if there isn't any new evidence, you can't reopen the case. So excuse me. Our standard there, is there a credible claim of innocence? And then are there any new leads to be followed? And if there are, we'll investigate the case. Now, these investigations are only step one. These investigations can last a few weeks or several years. The case I'll be talking about, we investigated for more than 7 years before finally deciding we could litigate it. Most of our investigations end in us rejecting the case because we are unable to find the evidence we would need to litigate the case in court. We've only accepted about 70 cases. So if you're doing the math there, 70 out of 7,000 applications is about 1% of our applications have actually been accepted for litigation. Of course, some are still being reviewed. And, given that we are part of the curriculum at the University of Michigan Law School, all of the work is done by law students who are enrolled, take the clinic for credit. We have a lot of clinical programs, and the Innocence Clinic is one of them. And they do the work under supervision of 3 supervising attorneys, including myself. I told you earlier that the initial 20 years of DNA exonerations taught us some lessons about what can go wrong in the criminal justice system. And here are some examples of what people who have studied this, including Professor Sam Gross at the University of Michigan, I think one of the earliest studiers of what goes wrong. What has gone wrong here? We can get that. All right. So here are some of the factors that have come up repeatedly in exoneration cases. A defense attorney who didn't do their job or did not have the resources to do their job. The criminal justice system tending to be overcrowded, where cases are rushed and people are not given the opportunity to make their case. This has come up in some areas as well. False identification, including both misidentification and perjury, have come up in a number of these cases. Junk science, outdated science is unfortunately a very common one as well. Misconduct by any number of actors in the system. I will stress again, this is rare, but there are documented examples of police officers fabricating evidence or misstating evidence, and even prosecutors doing that, as I'll speak about in a case example. The one that is probably hardest for people to accept is false confessions. Why would anyone confess to a crime they did not commit, especially where that confession can lead to a long prison sentence or potentially worse? That's a great question that psychologists have studied for a number of years. But what we do know is that it happens. About 1/4 of the people who have been exonerated through DNA actually had confessed to their crime. And later, it was proved via DNA testing that they did not commit the crime. It's hard to convey what it would feel like to somebody who is being interrogated in a police setting, what that would feel like, how you might actually confess to a crime you did not commit. There are some interesting cases that can be explored on this, some movie recommendations I could make should you want to learn more about that. And as I say at the bottom, almost always, a wrongful conviction is a collection of mishaps. You'll almost always have more than one of these present. And so with that background, I'll talk about one of our more recent exoneration cases. This came out of Oakland County. And that is my former client. Well, he's exonerated, so former client. Jawan Deering, who you can see was convicted in 2006 of 5 counts of first-degree murder in Oakland County, and he was exonerated September 30th of 2021. Now, Jawan's case involved a house fire in Royal Oak Township, where 5 young children died in this fire. So you can imagine the immense tragedy that was and the immense outrage there would be at the suggestion that someone set this fire on purpose. And so that is what colored this case from the beginning. We have a tendency as humans to think where something very consequential has happened, something as terrible as the deaths of 5 children, we have a tendency to think there must be a very big cause. But sometimes there isn't. Sometimes it's a very unfortunate accident, which is in fact what this case was, as I'll get to in a minute. So as I say, we have a house fire in Royal Oak. 5 children died in the fire. We've got a message up there. There were other people in the house who had survived the fire, and one of them, who was a child who was, on the front in the front living room sleeping on the couch, became the main witness. He was initially the one who said he heard voices on the porch, and he was the one who got people thinking that someone had come and ignited the porch on fire. Jawan knew the children's father, and it was alleged that the children's father owed Jawan money for drug debts. Alleged, but never proven. And for 6 years, no one was charged in this crime. So this terrible tragedy happens in 2000, and until 2006, there are no charges. In fact, the initial prosecutor assigned to the case refused to charge the case because he felt there wasn't enough evidence to charge anybody. However, over the period of 6 years, police, in that instance, the Oakland County Sheriff, arrested Jawan several times for minor things, including driving on an expired license, and held him in jail. And during those periods of time, they would put jailhouse informants, people who were working with the police, into his cell. And wouldn't you know it, later on, while Jawan has denied setting this fire to everybody, these 3 informants would testify that he told them he set this house on fire. So the evidence at trial ends up being the testimony of these 3 jailhouse informants and a fire expert who testifies for the prosecution and says that the house was set on fire intentionally with the use of gasoline, and the defense did not consult or present a fire expert. Now, both of these lines turn out to be very problematic. There are questions about the case from the beginning. The jailhouse informants said they were not being given any incentives to testify. This was something the defense questioned but never had any evidence of. The informants repeatedly told the jury they were only doing this to do the right thing because Jawan Deering had confessed to them and they wanted to see justice done, and they weren't going to get anything in exchange for that. In fact, the prosecutor repeatedly asked them if they were getting anything in exchange, and they kept denying. The other thing was that the forensic fire scientist testimony that was presented by 2006 was very questionable. The world of fire science had changed a lot by then, and the factors that were being used to imply that gasoline was used were in fact very much contested. But like I said, the defense attorney never consulted an expert of his own and certainly did not present an expert of his own. So these were the questions that we had when this case was first sent to us in 2010. And like I said, we investigated it for about 7 years before finally accepting it and litigating it. And so some of the things that we discovered, like I said, there was this background of a revolution in the world of fire science. And, you know, in the 90s and the early 2000s, there were all of these beliefs that if you saw certain kind of burn patterns, then you knew gasoline was used. Later scientific testing has shown that those burn patterns can actually be caused even when gasoline is not used. And as that bottom piece says, potentially hundreds of people were wrongfully convicted of arson across the country in a period when there were certain assumptions being made that the science simply doesn't back up. So we accepted the case, and based on this change in science, based on 2 world-renowned experts saying that this case was most likely an accidental fire originating from improper electrical wiring and not arson at all. That was the evidence we brought to the case, to the court. Unfortunately, hearings were denied, and we lost all the way through the state courts. However, Oakland County elected a new prosecutor in, I believe it was 2020, which gave us another chance. So we approached this prosecutor, Karen McDonald, asked if she would review the case, and she agreed. She appointed a special prosecutor to review the case, and then found a wealth of misconduct from the prior prosecutor who had handled the case. Now, remember what I said. The initial prosecuting attorney assigned to this case had concluded there was not enough evidence to charge the case and had declined to charge the case. And then a second prosecutor was brought in who suddenly decided he would charge the case. Well, that second prosecutor, it turned out, had committed a number of violations. The Detroit Free Press reported on this throughout 2021. I've got some headlines there. Basically, there were incentives given to the jailhouse informants that were not disclosed. In fact, the jailhouse informants were told exactly how to testify, and that all of that was not disclosed. Thankfully, the new prosecutor who was elected in 2020 felt that she could not cover this up, and she released all of this not only to us as Jawan's defense attorneys, but also to the media. And this was some stunning stuff. There were letters between the jailhouse informant and the trial prosecutor where the informant is saying, "Hey, I hope you thought I did a good job today. Now can you do this for me?" So it was pretty clear quid pro quo there. That this was overwhelming evidence of misconduct, and it led Prosecutor McDonald to announce that this was not a conviction they could stand by, and they would throw out the conviction, and Mr. Deering would be released. Interestingly, in doing this, she went to war with the county sheriff's department. The sheriff was constantly speaking against her and felt that this was a perfectly fine conviction. Unfortunately, as more and more has come out, the misconduct of the Oakland County Sheriff Department in this case has been shown to be fairly substantial, and Jawan, since his release, has in fact filed a lawsuit against them, and I think more will come out in that time. I've got some photos here from the day of his release, Jawan with his daughter there in the first one, daughter and grandchildren in the second photo there, and then at the top there's a photo of me, Jawan, and actually a different man, Anthony Kiles, who was exonerated a year later, and he was tried of the same type of crime, an arson fire in Oakland County, by the exact same prosecutor who had also used incentivized jailhouse informants in his case. So both of these were the same prosecutor committing the same kind of misconduct multiple times. And again, remember, these were cases where other prosecutors in that office had declined to charge the case. And yet, one person had gone forward and said, well, I'm going to try it anyway. That prosecutor, by the time these cases came out, had been working in the Attorney General's office, and he was, in fact, put on leave and then subsequently left the office as he remains under investigation for the misconduct in these cases. So that's a little sample of the work that we do in the Innocence Clinic. Like I said, we've had 40 successfully completed cases. Some, like Jawan, are people who are fully exonerated, who, the prosecution even has admitted that they were wrongfully convicted. Others are people who were granted commutation by the governor, for example, so they're released and they've gone home, but they still have the conviction on their record. And so, there are different levels of victories in these cases, but for all of these people, of course, you take the freedom that you can get, right? So if they're able to go home after being wrongfully convicted, we're happy to take whatever path that takes. I'll stop there. I will have time for questions at any time. So, in the trial itself, the jury will often wonder, hey, is this person receiving a benefit? So a good prosecutor will always make clear that they're not receiving a benefit. Hopefully that's true. It is not illegal to give someone a benefit in exchange for their testimony, but that needs to be disclosed. In this case, repeatedly the jury was told they were getting no benefits, and then years later, the new prosecutor, turned over documents that showed that wasn't true. In fact, there were internal letters summarizing how many times these informants had received benefits. Because, it happened so much, they needed to keep notes on it. So yeah, this was a fairly obvious case of misconduct, to be blunt.
I had a question about what actual innocence means in the context of the work you do. In Massachusetts, where I practiced criminal law for 20 years or so, there was a notorious case about 10 years ago where a forensic pathologist at the state police crime lab falsified drug analysis reports. Suffice it to say, the long and short of it is it led the state Supreme Judicial Court to summarily toss out 61,000 convictions. So how would that have played if someone came to you? Would they have to have actually been found not to be dealing drugs, or would the fact that the tests employed by the state to prove guilt were severely deficient been sufficient for you to take the case?
Yeah, so that's a great question. I think the specific criteria may vary from one Innocence Clinic to the next. My view, and I think the view of our clinic, has been if there is no evidence of guilt, then we will take that case because we see that as a case of actual innocence. And so, I've had clients that were convicted on the basis of junk science, and later everyone agrees, including the prosecution's expert, that the evidence they used at trial was problematic and that it's not credible and they can't stand by it. I think it would be unfair to say at that point, oh, but you have to have additional affirmative evidence of innocence. If there was no evidence of guilt, then to us that would equate with actual innocence. I think that's probably how those drug cases have been dealt with. But to be honest, I'm speaking from the perspective of an Innocence Clinic. From the perspective of us as a community and the judicial system at large, whether we call it innocence or not, if someone was convicted on fabricated evidence, at the very least, that conviction should be thrown out, and there should be a new trial based on what the real evidence is. So, that's probably an example of some people may call it innocence, others may not. But regardless, I think we would have big problems with a conviction based on falsified evidence. Yeah.
My question has two parts. Are there other law schools in the state of Michigan with programs similar to yours? And are there programs like yours in other states?
That's a great question. So in Michigan, our program at the University of Michigan Law School handles the non-DNA cases, and then there is a DNA Innocence Clinic at Cooley Law School that handles the DNA cases in Michigan. There's also a small program at the U of D Mercy Law School that is somewhat similar. It handles conviction integrity unit cases for the Wayne County Prosecutor's Office, and they have an internal unit to review convictions and find innocent people. So U of D Mercy has that. Overall, all these programs are part of an umbrella organization called the Innocence Network, which includes 70 members. About 50 of those are in the United States, and then about 20 are in various other countries. So yeah, there's plenty of them. Yeah.
Dave Lamoureux here. My question is, are the people that are released, are they, and I'm not sure I'm going to say this right, but are they remunerated? Do they get paid for this at all?
That's a good question, and the answer can vary state by state. In Michigan, a law was passed, I believe, in 2016, that says if you are exonerated, as in you've shown you're innocent and you're released from prison based on your innocence, then you can file a claim for up to $50,000 for each year that you were wrongfully convicted. Now, initially, claims were strongly litigated by our Attorney General's office, and a lot of people who would appear to be deserving did not get that money. Lately, the Attorney General's office has changed their view, and a lot more people have gotten that money. Now, aside from that, there's the possibility of filing a civil lawsuit if your conviction was due to someone committing misconduct. And the someone, this is getting into the weeds, if it was a prosecutor, prosecutors have absolute immunity, and it's very difficult to sue a prosecutor. Not impossible, but extremely difficult. However, if it's the police also have immunity, but it's a lower form of immunity. And so where there's police misconduct, there can be civil lawsuits. So those are two ways that someone may be able to see some money. At the very least, that state compensation money will take 2 to 3 months, possibly longer. And a civil lawsuit will take 2 to 3 years and possibly longer.
How often are the people guilty of misconduct criminally charged? How often are they convicted? And how often are they successfully sued?
I think rarely is the answer to all of those questions. It's more common to be sued and held civilly liable and have to pay some damages, especially police officers. That does happen. As far as criminal charges, there are a handful of examples across the country where police officers who manipulated or fabricated evidence were held criminally liable and served, 2 or 3 years in prison. It's not going to be more than that. And then there's 1 or 2 examples I'm aware of where a prosecutor who truly fabricated evidence was held criminally liable. I think the example I'm thinking of was in Texas, where a man went to death row based on a falsified conviction, later was exonerated. And it was just a ceremonial thing where the prosecutor was held liable and I think sentenced to 1 day in prison, which was something though, because that doesn't generally happen. And we've had cases here in Michigan where there seems to be absolute slam dunk evidence of police misconduct, but the prosecutor's office, the state AG, choose not to pursue those cases. And I can't answer for that. Of course, they have to be able to prove the case, and maybe something that looks like evidence to me isn't enough to win in court. But it's extremely rare for people who commit misconduct to be held liable.
A couple of comments. First of all, I'd like to thank you for stepping in at the last minute and making an excellent presentation.
Thank you.
And the second one is, what a wonderful experience and valuable experience for these law students. So.
Absolutely, and that something that really shaped my own law school career. I was in this clinic as a student and have had the chance to remain, so that's been great.
I'd like to press your last answer one step farther. How about disbarring? bad behaving prosecutors?
I think that's a much likelier remedy because that's a process separate from the criminal courts or even the civil courts. There have been grievances filed with the Attorney Grievance Commission, and ultimately the State Bar of Michigan can disbar or at least suspend or in other ways reprimand. I'm not able at the moment to think of an example where that's happened, but I would see that as a much more likely possibility than.
There was a case in Arizona a number of years ago where a man was accused of arson in his family, and the little boy died, and he was put to death for that, but he was later exonerated as I recall. Do you know anything about that case?
I believe you might be talking about the Texas case of Cameron Todd Willingham.
Yeah, well, that was his name, yes. I thought it was in Arizona, sorry.
So that's a very famous case of where there were a lot of conviction or questions raised about the conviction, but the man was executed before those questions could be resolved. So some people believe that, after his death, he has been exonerated. Others say anything that happened after his death doesn't count. So, whether he's officially exonerated or not is an open question. But there were certainly a lot of problems with the evidence in his case.
The work you do a lot of times receives pretty high publicity, for good reason, of course, but it does tend to weaken the credibility that people have in our jury system a little bit. What I'm wondering is, why isn't our appeals system able to make your work unnecessary? Why are appeals not used to determine whether prosecutors have acted unfairly or not?
I think traditionally the answer has been people just don't understand that these types of things happen, and even though they're rare, rare is still a significant number of cases across the country. Our appeal system is built not to re-adjudicate the entire trial, right? In our system, the jury's verdict is supposed to be the main event, and if you're going to challenge a jury's verdict, then you need to have very significant evidence. So on appeal, there's a presumption that the jury got it right. And so that's a tough presumption to overcome. And in all of these cases that I'm talking about, it takes some new evidence to overcome what happened at trial. And in an appeal, they happen kind of quickly, and there are rules. It's very hard to bring new evidence, is kind of the simple answer. And sometimes that evidence doesn't emerge until years after the case. So I guess those are parts of the answer why the appeals that happen right after a trial are often not enough. Now, I'll make clear, there are people whose convictions are reversed on appeal because they were able to find evidence of misconduct. But it doesn't happen all too frequently.
Or do we need to change our appeals system to make room for that kind of situation?
Sure. Yeah, and I think you'd have kind of arguments for and against that. Some people would feel, that would be kind of undermining the jury system. Others might feel that we do need to have more robust processes to review convictions because that's the purpose of appeal. So yeah, I think those are important conversations, of course. Yep.
I was curious about some of these when someone's exonerated and get paid back by the state or in a lawsuit, two different cases. I was wondering if they're subject to tax by federal or state, as this is a very large piece of money coming suddenly.
The state compensation is not taxed, so the $50,000 a year without tax. And that comes out of the state's budget, and so that has been, part of the state's budget each year. As far as civil lawsuits, I believe generally they are taxed.
Question. In your experience with, say, those 70 cases, what is the length of time a person is in prison before they're exonerated?
I would say an average is about 15 to 20 years. The longest time that any of our clients served was 46 years before he was exonerated. And we have had cases where it happened within a year or two, but yeah, that would be kind of the range.
I have one more question too. If forget the money that someone has been paid after they've been exonerated. Are there support systems given to these families? I can't even imagine the ripple effect of children and grandchildren and siblings and parents when they've got somebody in jail for 46 years that didn't do the crime. Right. We can't just let these people loose. So are there state supports that we give them?
You know, I think your question is important because you asked about the families. And I think there really are not support systems for people's families. Only recently have we begun understanding that when someone is released after years in prison, they need certain support systems. And groups of exonerees themselves have created important services for newly released people. And then, you know, our state legislature has passed a bill that enables people who are exonerated to get certain services like housing assistance and job training. There's a long way to go on that. And I think the harm that's caused to families is not really something we've begun to really even address.
Maybe this is something our voucher program can get really hooked into. There may be people who really need to start over with furniture and things, and we might get a lead on some of these families. But, all right, thank you.
Absolutely.
I have a follow-up question. Also, how many of these cases of factual innocence is the miscarriage of justice attributed to the quality of defense representation? And of those, is it mostly indigent defense, or are not? I ask because in Michigan, the Supreme Court has appointed a committee to study how indigent defense is funded. I'm going to sound like I'm beating the drums for Massachusetts, and I don't mean that way, but in Massachusetts, it's state-funded and state-administered rather than being left up to the discretion of individual counties. How much of a role does the quality of indigent defense in Michigan play in these convictions?
Yeah, it plays a huge role. I would say, you know, I haven't done the math, but it would probably be virtually every case that involved some sort of shortcoming from the defense attorney, either because they didn't put in the effort that they should have, or they simply didn't have the resources to do it. And you're right in that for years, Michigan had a very, very broken public defense system. Washtenaw County, I think for years, was the only county that had a public defender office. The Michigan Supreme Court about 10 years ago started this undertaking of indigent defense reform, and that has come a long way in Michigan. I think many, many more counties, I want to say upwards of 25 or 30, now have public defender offices. And I think while public defender offices are not necessarily a silver bullet, having an institution that serves the defense of the community as opposed to individuals is an improvement. There's a reason we don't have individuals acting as prosecutors, right? We have a prosecutor's office that has resources and investigators and everything like that. So I hope the indigent defense situation in Michigan is improving. It's still going to be administered on a county by county level. And anyone that's seen a state administered office as you have would know about the strengths of a state administered office. But here we have a lot of county level interests that I don't think will allow a state administered office to function. I will say that a lot of our clients paid to retain an attorney who then did a terrible job for them. So that's, I guess even worse if you paid out of pocket and then had a terrible attorney. So, yeah. Oh, sure, yeah. Go ahead. So, we had a real flood of letters coming when we first opened. Now it's kind of trickled down. They're from the incarcerated people themselves. Sometimes they're families. Yeah, sometimes they're families. Whenever we get a letter, we'll say, okay, here's the full application to fill out. And it's, a lot of details about the case and who was your attorney and what claims did you make on appeal and all of that stuff. And then that starts the process of review. But yeah, we've never done any advertising other than, our cases being in the media. And everyone in prison quickly learned about our clinic. And within a couple of months of opening, we already had thousands of applications come in. So. What's that? Of course, yeah, for sure. A lot of those.
All right.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, and
Indivisible,
indivisible with liberty
and justice
for all.